Reagan Richards, Legal Services of Northern Michigan, on behalf of Johanna Adams, who is seated behind me.
All right, thank you. Mr. Blumberg, is your client with you in your office there?
No, Judge, he's not. I told him he didn't have to be here. This motion has to do with my disqualification. Mr. Dick has also filed a motion. Is he participating today?
I have not seen a motion from Mr. Dick.
Your Honor, that motion was for the PPO. We filed a motion in this divorce case and then the PPO. This hearing is just for the divorce case.
All right, so I have not reviewed anything from Mr. Dick involving these parties that I'm aware of. All right, the motion to disqualify comes from defendant, so I'll let them go first, and then Mr. Blumberg, I'll give you an opportunity to respond. So go ahead, counsel.
Thank you, Your Honor. Our motion is based on representation by Mr. Blumberg of Ms. Adams in a criminal case approximately 8 years ago. According to the Michigan Rule of Professional Conduct 1.9a, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interest of the former client unless the former client consults after representation. We believe that these matters are substantially related. The courts have used a substantial relationship test, which looks at if there is a close relationship or likelihood that the confidential information will have relevant to the subsequent representation. And that has been stated by the Attorney General in an opinion attached to our brief from March 28, 1990. And we do believe that there is a likelihood that the confidential information obtained will have relevance as moral fitness is a best interest of the child factors. And there is a minor child whose custody is at issue in this case. In Mr. Blumberg's brief, his interpretation of the same or substantially related test is counter to case law and a reading of the statute. It does not say anywhere in case law or in the rules of professional conduct that the cases must be virtually identical to be substantially related. And in fact, if that were the case, there would be no reason to include substantially related in the statute. Finally, it does not matter if the information obtained is used or public record, if there was no confidential information retained, or if Mr. Blumberg states he does not remember. The appearance of impropriety is enough. We believe that this is a big deal, or else we would not be filing a motion. It is just enough that there is even the possibility that Mr. Blumberg has confidential information that he could have obtained from Ms. Adams that could be used against her in this case. Thank you, Your Honor.
Mr. Blumberg.
Judge, I have practiced for 42 years, and I have never seen a case where, first of all, that I've ever been sought to be disqualified, but certainly my representation of Ms. Peak 8 years ago in a completely unrelated case, a misdemeanor case that we've destroyed the files. I've not had any recollection of even the events of that case. I have signed an affidavit attesting to the fact that there were no confidential communications that were made to me that I recall. And again, her name is attached to the filing, and yet there is no affidavit. There's no assertion of even the nature of the alleged confidential communications. This is a clear case to get me removed so that, in fairness to Ms. Richards, who has not been practicing very long, not to have someone who has been experienced to be representing Mr. Adams in this case. I have a different view, and in our brief, we've put into our brief what the test is and what determines a substantial relationship. And I'm quoting right from MRPC 1.9. In deciding whether a substantial relationship exists, the scope and subject of the prior representation and the current representation is reviewed. There is no analysis even applied to this motion that would in any way talk about or compare the prior criminal matter or custodies at issue. Whatever Ms. Peak did or didn't do 8 years ago has no bearing on the best interest factors as it relates to during this marriage. Conduct during the marriage is the analysis for the court in a custody case. Again, I have signed an affidavit attesting to the fact that there are no confidential information that I have or I could be using to prejudice Miss Peak. She simply is trying to exclude me from representing her husband. The fact that she called me after this matter was filed to represent her, and I didn't even take the call. I told her I couldn't talk to her. So clearly, they have gone and taken every step imaginable to try to get me disqualified from this case. My client deserves to be represented. I've taken on this case with the understanding that my representation 8 years ago had no bearing. I researched the law before I agreed to take this on. And again, without being disparaging, I think there are some other ulterior motives in the filing of this motion. There is no substantial relationship between this very short-term marriage and a misdemeanor criminal matter from 8 years ago. In a small town where there's so few lawyers, this would be the means to get somebody disqualified at the drop of a hat. And I'm also a bit taken back by the timing of this. I know that when a judge is sought to be disqualified, when there is determined to be a basis to do that, there's 14 days before which you have to file your motion. I'm going to be very delicate in my presentation to the court. I genuinely believe that Ms. Richards has taken this on with the express intent of getting me removed, and I find it to be offensive, and I would ask the court to deny this motion.
All right. Thank you very much, both of you. Ms. Richards, as the party asking for that, is there any final rebuttal that you would like to make at this time?
Yes, Your Honor, thank you. I would just like to state that Miss Adams did not need to show what confidences may have been made, and that would, in fact, be contrary to what we're trying to protect. We're trying to protect her confidences, so forcing her to disclose what she might have said would go against that. And the case law supports that she does not need to show that there were confidences that were disclosed. The mere possibility that there were is enough to disclose him. I also find it extremely offensive that Mr. Blumberg would outright state that I am trying to get him disqualified because of his experience. This motion has been filed for the express purpose and the only purpose because we believe that there is a conflict of interest that puts my client at risk of having confidences disclosed to Mr. Blumberg being used against her. I find it extremely offensive that he would think that I would file a motion of this severity for pretextual reasons, and that I would just like to state firmly that this motion is filed because we do believe that there is a conflict of interest.
All right, thank you very much. Ms. Richards, what would be the need for me to rule on this motion if there were an agreement that nothing from the criminal case could be used in the divorce case?
I would still ask that Mr. Blumberg withdraw because this would protect not only Miss Adams, but Mr. Adams as well. The moral fitness is a factor in the best interest of the child case. At every custody hearing, do you have a criminal record is a question that would be asked. I think it would disadvantage his client if that question could not be asked, and I don't know if there is a way for that information to be brought up without the potential of confidential information being brought up.
Mr. Blumberg, is it your intention to ask questions as to the moral fitness of the opposite party?
Let me respond to it this way. The moral fitness factor only addresses the morality and the ability to parent the child. It doesn't go into 8 years ago, whatever behavior may have been displayed. It's what happens during the marriage, and is there some deficiency in her morality during this 1.5-year marriage? It's not my intent. And as an officer of the court, I don't think I have to bring that up. I think the merits of the case will be made without that factor being considered, or at least through my questioning of that.
So, Mike, thank you for that answer. Let me make sure I have the fine point on it. The question is whether or not there would be any evidence related to the criminal matter that you represented Ms. Adams or Peak on within the divorce case. You're telling me that you don't believe that there is. If we were to sign if I were to sign an order today indicating that that cannot be used, would that, you believe, would that be disadvantageous to your client's case? Or let me put it this way, would you stipulate to such an order being entered?
I would, but what I would not stipulate to is her conduct during the marriage, because that is completely unrelated to what may or may not have happened 8 years ago.
All right, and what you're telling me is that your professional relationship with her was 8 years ago, and it was not recently during the marriage. Is that correct?
Right.
All right, so the only issue that we're arguing over is whether or not the criminal case 8 years ago would be substantially, or would have a substantial relationship to the divorce case now. And your understanding is that the only substantial relationship that could be made in this case is based on the actions of the criminal case, and you're saying that that's not going to be used in the divorce case as far as you're concerned.
No, again, my rather vague recollections of that case is that it had nothing to do with domestic violence, which is the issue in the current divorce by virtue of the personal protection order. So I'm not trying to evade answering your question, and maybe I didn't, but they are completely unrelated.
All right. Ms. Richards, if the court were to enter an order that says that the issue of the criminal case 8 years ago cannot be brought into the divorce case, is there then any further need for a decision on disqualification of Mr. Blumberg?
I do believe there is, Your Honor, yes, because it's not necessarily just the facts of the criminal case, it's potential confidences that could have been made by Ms. Peak or Ms. Adams to Mr. Blumberg. Further, Mr. Adams has already brought up the criminal case in his custody paperwork, showing that he intends to, he at least before retaining Mr. Blumberg, intended to use it. And the case law is very, very clear on the fact that even if there is the potential appearance of impropriety, it warrants disqualification, because this is a very serious issue, and it may be just one issue in this case. However, cases set precedents, and what may not be one issue in this case could then be an issue in the next case. And I believe that this issue is such an important issue that it warrants a strict reading of the rules of professional conduct and disqualification.
What is the next case that you're referring to?
Just not necessarily the next case, but if this case sets a precedent that that just eliminating one issue could resolve this conflict, then another case down the line could also not disqualify an attorney in a situation where there is a conflict.
Well, I appreciate the fact that you think that I set precedent, but I strongly believe that this is a very, very important issue, and as attorneys, we have a very serious job and we have a lot of responsibilities, and maintaining client confidences is such a big deal. And I believe that is why I filed this motion. I understand that this is an extremely serious motion, and I believe strongly that maintaining client confidences is an important part of our job. We have a lot of power, and it's important that we don't abuse that power. All right.
And I can't emphasize enough how offended I am by this. To assert in some general way,
Mr. Blumberg, I got you, Mr. Blumberg. Okay. I absolutely understand, and I took that very seriously from you. I also take the same statements from Ms. Richards very, very clearly, very seriously as well. So I got that. So okay. Let me walk myself through this process of ferreting out where we're at and what we're doing. I am referring to a case that's unpublished, but I think it states the law very clearly, and it helps my analysis. So I'll state it on the record what I'm looking at. This is Morgan versus Ford Motor Company. It's the Court of Appeals docket 362260 from August 17th of 2023. It is an unpublished case, but as I reviewed the motions and the filings of today's thing, it appears to state it is one of the most up-to-date statements of the law that I could find. So therefore, I'm going to use that in my analysis. It says that a party seeking the disqualification of counsel bears the burden of demonstrating specifically how and as to what issues in the case the likelihood of prejudice will result. And that's from Killingbeck versus Killingbeck, 269 Mishap from 2005. And says that the existence of a conflict of interest that disqualifies counsel is a factual question. The court then goes on to state the rule of professional conduct 1.9, as has been addressed by both of counsel in this case, that says addresses conflicts of interest that arise when an attorney's representation of one client is adverse to another or former client. Under subsection 1.9, subsection A, a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter to which that person's interests are materially adverse. I think can clearly find that the parties in a divorce case are materially adverse to each other. Their interests are materially adverse. So the question, and in this case, it's clear that the previous representation was not the same as this one. So the question becomes whether or not they are substantially related matters. The court in the case that I'm referencing says that the attorney breaches his or her fiduciary duty to a former client only by undertaking representation of a client who has interests both adverse and substantially related to the work that the attorney performed for the former client. A lawyer who recurrently handled a type of problem for a former client is not precluded from later representing another client in a wholly distinct problem of that type, even though the subsequent representation involves a position adverse to the prior client. In other words, all subsequent representations of a adverse client are not indicated by the rule. It only is where there's a substantial relationship between the two things that the rule would be applicable. And there is a three-prong test to determine whether or not the representation of the adverse party is substantially related to the previous representation. The first part of that test is the nature and scope of the prior representation. It appears that the prior representation by Mr. Blumberg of Ms. Adams/Peak was a criminal case, misdemeanor case. I've not been told what the subject matter of that was, but it appears that there was a misdemeanor criminal matter of representation approximately 8 years ago. The second part of the test is the nature of the present lawsuit against the former client, and that is a divorce case, which they are not the same. Criminal and divorce matters, and especially where they are separated by 8 years in time, are not always substantially linked. And then the third issue is in the course of the prior representation, whether the client might have disclosed to his attorney confidences which could be relevant to the present action and could be detrimental to the former client. And it appears that the area that would encompass would be the morality and or domestic violence. Those would be the two best interests of the child factors where that might come up. Mr. Blumberg has indicated that he is not aware of the previous matter, the criminal matter being involving domestic violence, and that leaves only the morals or the morality factor. And he again has indicated he does not believe that they would, as to the time during the divorce, would be related. Ms. Richards, your client has her hand up. You might want to speak with her while I'm doing this. So that's the issue before me, is whether or not under that three-part test, the divorce case and the issue of the morality or the morals, the moral fitness would be information available to Mr. Blumberg in the divorce case, and whether or not there would be an appearance of impropriety from that would allow me to, or would require me to find that he should be disqualified. Ms. Richards is correct that there is a presumption that an attorney receives confidential communications in the course of representing his client. But this court case that I'm citing, Morgan versus Ford Motor Company, also notes that, however, mere disclosure of confidential information to counsel in the course of the prior representation is not itself sufficient grounds for disqualification of that counsel when he later represents an adverse party, because there may not be that substantial relationship test. I am of the mind that if I were to enter an order forbidding Mr. Blumberg from bringing up the fact of the prior criminal case, because the criminal case preceded the time period of the marriage and therefore precedes the divorce issues of custody and parenting time, that should satisfy this matter, because there would be no substantial relationship between the two cases, and therefore no additional issues of the appearance of impropriety to be brought out. And so I'm going to enter an order that allows Mr. Blumberg to remain within the case, but he would be limited in his argument and in his factual assertions to not include anything that has to do with the criminal case that was the representation that he had of Ms. Peak / Adams 8 years ago. If any of that information does come up or come out, then I would allow Ms. Richards to renew her motion for disqualification, and I would likely disqualify Mr. Blumberg at that time. The reason I'm doing so is because I don't believe that there is a substantial relationship between the two cases with that proviso in place. And I also believe that Mr. Adams has the right to and the need to have good, experienced counsel of his choice. And I believe that that is a proper interest to protect as well, especially in a small town where it's not always available to you because of the lack of a large amount of attorneys. So the court will enter an order of its own. I'll draft that order. And is there anything else that we need to do today, Ms. Richards?
Nothing from us, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
All right, that's all for today then. Thank you very much.
Thank you, Your Honor.